Welcome to the Tejswi IP show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication, design. Also analyze the recent event in IP world. Welcome to the debate. Today, we're unpacking a pretty pervasive myth that just continues to circulate among a lot of Indian companies and exporters. There's this widespread assumption that filing for a patent in China is merely a defensive formality, just a box to check on your global compliance checklist.
Right, the old file it and forget it strategy. We see it all the time.
Exactly. But through our internal analysis here at Tejswi IP, we've observed something entirely different. China conducts highly rigorous substantive examination, particularly when we're looking at the mechanical and chemical domains. It is definitely not just an administrative rubber stamp. So the central question we are exploring today is, what is the primary cause of failure for Indian exporters when they file their patents in China?
And it's a critical question, right? Because getting it wrong, it costs these companies a tremendous amount of money and, frankly, market share.
It really does. My position is that the core vulnerability is primarily linguistic and procedural. The fatal flaw really lies in translation risk and structural misunderstandings. We see it constantly with issues like claim tree compression. I argue that to succeed in China, an applicant has to front-load their translation engineering and meticulously adapt their structural framework to match local expectations.
And I take a fundamentally different view on where the true vulnerability lies. While I agree that the Chinese examination process is exceptionally rigorous, I argue that the core vulnerability for Indian exporters is fundamentally substantive and strategic. The fatal flaw isn't just about how the words are arranged. It is about incomplete prior art risk modeling and a remarkably dangerous false reliance on international PCT search opinions. To secure a resilient asset in China, you have to overcome the jurisdiction's unique internal logic on novelty and inventiveness against localized prior art.
Okay, let's actually look at the mechanics of that. When an Indian company files a patent in China, they often treat the process as a direct one-to-one transfer of their domestic filing. They assume that if the English specification is robust, it will naturally yield a robust Chinese patent. They figure just run it through a standard translation service and you're good to go.
Which is terrifying, honestly.
Right, because the reality is that the root cause of failure is linguistic. Claim scope erosion in China is almost never the result of examiner hostility or some anti-foreign bias, which is a common misconception we hear from clients. Instead, it happens because technical nuance completely collapses during the translation process.
I come at it from a different way. I certainly do not dismiss the complexities of translation. It's a massive hurdle, no doubt. But we have to look at the substantive foundation of the patent itself. Even if you achieve absolute, flawless translation integrity, say you have the best technical translators on Earth, that patent will still fail if the substantive foundation is weak.
I see why you think that, but let me give you a different perspective. Think about functional claiming. In English, we love to describe a component by what it does, rather than what it structurally is.
Oh, sure. The classic means for fastening, instead of just saying a steel bolt.
Exactly. It gives you broad protection in India or the US. But when that functional language is translated into Mandarin, it frequently becomes incredibly ambiguous. It's like translating a highly specific recipe. If a precise technique like, say, sautéing just gets translated generally to cooking, you're going to end up with a very different meal. In patent law, that ambiguity is fatal. It inevitably invites restriction. The examiner will issue an office action citing a lack of clarity, which forces the applicant to make narrowing amendments. And once those amendments are on the record, your enforcement posture is permanently weakened.
I agree that ambiguity is dangerous, but the real shock to the system for Indian exporters isn't just the clarity rejections, it's the intensity of Chinese prior art searches. Chinese examiners are exceptionally thorough. Crucially, that actively cite local language references that are completely invisible in standard international search databases.
You mean the local utility models and domestic journals?
Exactly. China has a massive two-tier patent system. They grant millions of utility models, which are basically unexamined short-term patents, and they publish them locally.
We are talking about vast databases of Chinese utility models, local academic journals, and domestic industry publications that never ever get translated into English. If your initial prior art mapping relied solely on standard English language databases, your risk modeling was inherently incomplete from day one. You are walking into a substantive examination entirely blind to the actual prior art landscape the examiner is holding in their hands.
That's an interesting point, though I would frame it differently. Yes, the prior art search is intense, but the mechanism by which an examiner applies that prior art is fundamentally linguistic.
How so? I mean, if the prior art exists, it exists.
Because when technical nuance collapses in translation, the examiner reads the ambiguous Mandarin text and interprets it far more broadly than the applicant intended. Because the text is broad and ambiguous, it suddenly reads onto a vast ocean of local Chinese prior art that would not have been relevant if the precise technical nuance of the English original had been properly captured.
So you're saying the prior art rejection is just a downstream effect of bad translation?
Exactly. The prior art problem you are highlighting is often a symptom of the underlying translation failure. Let's say a mechanical gear assembly is described using terms that lose their specific geometric constraints in translation. The examiner will naturally cite a basic, pre-existing Chinese gear assembly as prior art. The applicant is then forced into a corner. They have to amend the claims not just to overcome the prior art, but to fix the clarity issues. And because of the strict rules against adding new matter once the application is filed, they're trapped. They can't reintroduce the nuance that was lost in the initial translation. This is why front-loaded translation engineering is the true critical path.
I'm sorry, but I just don't buy that the prior art issue is merely a symptom of poor translation. Let me tell you why. Let's look at the chemical domain, where the language is arguably much more standardized globally.
Right, you got standardized nomenclature, IUPAC names, molecular structures.
Exactly. Chemical formulas and molecular structures do not suffer from the same functional ambiguity as mechanical claims. A benzene ring is a benzene ring, whether you're in Mumbai or Beijing, yet Indian chemical companies still face massive hurdles in China. Why? Because the Chinese examiner pulls up a domestic Chinese thesis paper from 10 years ago that discloses the exact same compound, or maybe an incredibly close analog, which never made its way into the World Intellectual Property Organization search indices.
So the translation in that specific case is perfectly accurate.
Flawless. The structure of the claim is perfectly clear, but the patent is substantively dead on arrival. The vulnerability there is the strategic failure to conduct a localized prior art search before committing hundreds of thousands of rupees to the Chinese national phase entry. If an exporter doesn't actively map the Chinese language databases, they are effectively gambling. It's like walking into a casino and betting on a roulette wheel you can't even see. They are operating under the false premise that the global prior art landscape is fully documented in English, and that is a fatal strategic error.
Insurmountable barrier if they aren't structurally anticipated. This actually brings us to a major point of contention between us: procedural expectations versus substantive logic. Let's examine the structural miscalculations Indian companies repeatedly make with their claim trees.
The sprawling webs of dependent claims.
Right. In India, it is standard practice to draft highly complex, multi-layered claim trees. You might have a main independent claim followed by 20 dependent claims that cascade in a highly interrelated manner. It's an elegant way to capture every possible iteration of an invention. But unity of invention objections, the rules dictating that a patent can only cover one single inventive concept, differ vastly in China.
They absolutely do. They flatten those trees right out.
Yes, that's what we call claim tree compression. When you submit that interconnected web of claims to the Chinese Patent Office, it faces harsh structural compression. The examiner basically forces you to divide the application into multiple divisional filings, which skyrockets the cost, or they force you to abandon perfectly viable embodiments of your invention altogether. If you don't engineer the claim structure for the examiner's psychology and the specific procedural habits of the Chinese office, you lose the scope of your invention before the examiner even gets to the substantive novelty arguments.
That's a compelling argument, but have you considered the strategic error of assuming a PCT international search opinion is predictive of a Chinese examination outcome?
You mean the written opinion issued during the international phase?
Exactly. You are focusing on the formatting of the claim tree, which, while incredibly frustrating and expensive, is ultimately a curable defect. You can amend claims, you can file the visionals if you have the budget, but you cannot cure a fundamental misunderstanding of substantive logic. Indian companies routinely receive a positive written opinion from the International Searching Authority. They look at that clean report, which says their invention is novel and inventive, and they assume their path in China will be a smooth administrative formality.
I think they already have a pre-approved patent in their hands.
Right. And that is a massive strategic vulnerability. Relying on a clean PCT report in China is like assuming you can drive in Mumbai traffic just because you passed your driving test in an empty parking lot. The local environment is entirely different. That PCT opinion is not predictive at all. The Chinese Patent Office applies its very own internal logic to assess novelty, inventiveness, and the overall technical contribution.
Especially when it comes to incremental improvements, right?
Precisely. They have distinct guidelines on what constitutes a recognizable technical effect, especially in borderline cases involving incremental improvements in mechanical engineering or specific formulation ratios in chemistry. Misunderstanding this substantive logic and blindly relying on a PCT opinion is a far graver error than formatting a claim tree incorrectly.
I'm not totally convinced by that line of reasoning because the application of that internal logic is inextricably linked to how the claims are structurally presented to the examiner. You mentioned the assessment of a recognizable technical effect. How does a Chinese examiner actually locate that technical effect?
By reading the claims against the prior art.
Yes, but they look at the structural relationship between the claims to find it. If the claim tree is a compressed, convoluted mess because it was not procedurally adopted for the jurisdiction, the examiner cannot clearly identify the technical contribution. The procedural structure is the vehicle through which the substantive logic is evaluated. If you hand an examiner a poorly structured, badly translated specification, you trigger an inherently skeptical psychological response.
So you think they just stop looking for reasons to grant it?
Absolutely. They are no longer looking for reasons to grant your patent. They are looking for the fastest procedural route to restrict it. The substantive logic you are talking about does not exist in a vacuum. It is applied to the text on the page. Therefore, linguistic precision and procedural compliance must be the foundational priority. You have to speak their language, both literally and procedurally, to even earn the right to have a substantive debate about inventiveness.
I hear what you're saying about the examiner's psychology, but I think we have to look past the examination phase entirely to see where the true danger lies. This brings us to the ultimate end goal, the enforcement culture. A patent is not an academic exercise, it's a commercial tool.
Of course. The whole point is to enforce it against infringers.
Right. If an Indian company's commercial roadmap involves supply chain integration, manufacturing partnerships, or licensing inside China, the strategy must prioritize surviving China's rigorous localized novelty standards first and foremost. Let's assume you have achieved the perfect procedural filing. The examiner's psychology is satisfied, the translation is pristine, and you are granted the patent.
Sounds like a successful prosecution to me.
On paper, yes. But the moment you attempt to enforce that patent against a Chinese competitor, or even if your own manufacturing partner decides to challenge you, the very first thing they will do is initiate an invalidation proceeding at the Patent Reexamination Board. And what will they use to invalidate your perfectly translated patent?
The local prior art.
Exactly. The local prior art that you overlooked because your initial risk modeling relied on English databases. They will bring forward unexamined utility models and local disclosures that tear down the substantive novelty of your asset in a matter of months. A beautifully structured patent is entirely useless if it is invalidated. Therefore, understanding the substantive reality of the localized prior art landscape is the absolute prerequisite for any enforcement strategy.
I see why you think that, but let me give you a different perspective on the mechanics of enforcement in China. China actively enforces patents, and their specialized IP courts are actually highly sophisticated. But enforcement strength directly correlates with drafting precision and the clarity of the prosecution record, what we call the file wrapper.
The history of everything argued back and forth with the examiner.
Exactly. This is where the linguistic and procedural vulnerabilities come back to haunt the applicant. During litigation, Chinese courts heavily rely on that file wrapper. If your prosecution record is littered with desperate arguments about translation errors,
ambiguous terms, and forced narrowing amendments just to overcome those clarity objections we talked about earlier, you have created a severely weakened enforcement posture.
Because of prosecution history estoppel, you are bound by what you argued to get the patent granted.
Spot on. Ambiguous terminology that might comfortably survive in other jurisdictions where courts might take a more flexible approach or apply a broader doctrine of equivalence will actively undermine your litigation posture locally in China. Chinese courts tend to interpret claims very strictly according to the literal written word. If the translation left a functional term slightly vague, the court will not interpret it in your favor. They will limit your scope to the specific, narrow embodiments detailed in your specification.
So you're arguing the asset is effectively hollowed out from the inside?
Exactly. While surviving an invalidation challenge is obviously necessary, you can only enforce what you have clearly and precisely claimed. If you sacrificed claim scope due to linguistic failures during prosecution, you have nothing of commercial value left to enforce anyway.
But hold on, the prosecution record is exactly where substantive strategy matters most. If you walk into Chinese prosecution relying on that clean PCT search report, and the examiner suddenly hits you with 3 highly relevant Chinese utility models, your prosecution record is going to reflect a desperate scramble.
Well, sure, you have to amend around the art.
Yes, but you will be forced to make significant substantive concessions and sweeping amendments to navigate around art you never anticipated. That creates a disastrous file wrapper for litigation. The only way to maintain a clean, clear prosecution record that supports strong enforcement is to know exactly what prior art the examiner is going to cite before you even file. That allows you to proactively draft the claims and, yes, translate them well around that specific local art. It is the substantive anticipation of the Chinese prior art landscape that protects the prosecution record, not just having a linguistically perfect translation of an English application that is fundamentally blind to the local environment.
Let's look at a specific scenario in the mechanical domain to illustrate why procedural adaptation is so vital. Imagine one of our clients, an Indian exporter, designs a complex agricultural harvesting machine. The Indian patent application claims the entire machine as a single complex system, relying heavily on the interrelated functions of its subassemblies. The cutting arm connects to the sorting bin, which feeds into the propulsion system.
A classic, highly integrated mechanical patent.
Right. When that goes to China, if it is not procedurally restructured, the examiner will likely issue a unity of invention objection. They will demand that the cutting mechanism, the sorting mechanism, and the propulsion system all be examined separately. This structural compression completely fractures the core inventive concept.
They break the machine into pieces.
Exactly. The applicant is forced to choose which part of the machine to protect or pay exorbitant fees for divisionals. Even if they knew every piece of Chinese prior art in existence, the failure to engineer the claim structure to align with Chinese procedural expectations has fundamentally compromised their intellectual property. They lose the synergistic protection of the entire system. This is why I maintain that the procedural miscalculation is the fatal flaw. It dismantles the patent strategy before the substantive debate over prior art even begins.
I completely understand the pain of unity objections, but let's look at the alternative in that exact same scenario. Suppose they perfectly restructure that agricultural patent into neat, procedurally compliant divisionals. They spend the money, they play by all the structural rules you are advocating for.
Then they have a compliant application ready for examination.
Right. Then substantive examination begins. But because they relied on an international search, they are completely unaware that a provincial agricultural institute in China published a technical paper 5 years ago detailing the exact same cutting mechanism. The procedural perfection is immediately irrelevant. The application is rejected for lack of novelty. The core issue is that many applicants treat the Chinese patent system as an administrative hurdle to jump over, rather than a distinct technical repository with its own historical timeline of innovation.
You're saying they disrespect the local knowledge base.
Functionally, yes. Overcoming China's unique internal logic requires recognizing that their repository of knowledge is vast, localized, and largely distinct from what is readily available in English. It requires a substantive strategic shift, discarding the comfort of the PCT opinion and engaging with the Chinese technical landscape on its own terms.
And I would argue that engaging with that landscape on its own terms
is primarily a linguistic exercise. You cannot understand their technical landscape without understanding how technical nuance is expressed in Mandarin. The root cause of the disconnect is that Indian companies do not treat the Chinese filing as a distinct drafting exercise. They treat it as a translation exercise.
Which is a subtle but massive difference.
Exactly. To succeed in China, a patent cannot be an afterthought filing. It must be meticulously engineered for translation integrity, structural expectations, and examiner psychology. It requires an investment in front-loaded translation engineering, where patent attorneys and technical translators work collaboratively to ensure that the functional language and structural nuances of the invention are accurately and unambiguously captured in the target language. It requires abandoning the Indian style of claim drafting and adopting a streamlined, procedurally compliant structure that anticipates Chinese examination habits. Only by mastering these linguistic and procedural elements can an applicant secure a patent that is broad enough to be commercially valuable and precise enough to withstand the scrutiny of the Chinese enforcement courts.
While I appreciate the necessity of linguistic precision, my stance remains that a resilient patent in China fundamentally requires robust, localized risk modeling. It requires an applicant to look beyond the translation and deeply investigate the substantive reality of the Chinese technical landscape. You must account for Chinese language prior art databases and actively model your risk against them from day one. You must anticipate China's distinct internal logic on inventiveness, acknowledging that their threshold for what constitutes a recognizable technical effect may differ entirely from international norms. Most importantly, it requires discarding the false security of reliance on PCT opinions. A clean international report is not a shield against the rigorous, localized scrutiny of the Chinese Patent Office. Success requires building a substantive strategy that acknowledges China as a unique and highly developed technological ecosystem.
It seems we are approaching this from two vital yet distinct angles. However, I believe we share a powerful convergence on the ultimate takeaway from our internal analysis here at Tejswi IP. When we look at the entire landscape, whether it's the collapse of technical nuance in translation, the structural compression of claim trees, the hidden dangers of local prior art, or the misapplication of international search reports, the overarching truth is undeniable. Attempting a cheap, corner-cutting entry into China is unequivocally the most expensive misunderstanding in global patent strategy.
Absolutely. Treating a Chinese filing as a low-budget, defensive formality is a recipe for catastrophic commercial failure. By deeply considering both the linguistic and procedural nuances you've highlighted, alongside the substantive and strategic realities of localized prior art and internal logic that I've emphasized, we provide Indian companies with a complete, holistic roadmap for success in Chinese patent prosecution. It is a highly complex environment, and mastering it requires addressing both the form and the substance with equal rigor. Thanks for listening. Stay tuned for more upcoming episodes, and for reliable and expert intellectual property legal services, contact Tejswi IP today. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their intellectual property rights in the digital age.